Okay, so thinking about setting up a lifetime trust. Let's think about some things in regard to your goals for setting up a lifetime trust. Who could be the trustee of the trust, both during your life, upon certain events during your life, and upon your passing? What assets should fund the trust? And what are the terms of any particular trust? Who's to benefit both during your life and upon your passing? So let's start with goals. What could be some goals as far as setting up a lifetime trust? Well, one could be avoiding probate. So you want your assets not to pass through probate. Now, we could have a situation where we definitely want to avoid probate if at all possible. We have red flags in the picture, or we have a specific situation where probate would be problematic, if not downright difficult. And in those situations, we really do want to make sure, to the extent possible, that we can avoid probate. And I've seen situations where probate should have never been thought about as far as the way to pass assets, but we're stuck at that time. There's nothing that can be done. And certain people really have to plan proactively here because of those red flags and need to kind of heed the warnings as far as what's going to be a real problem and real difficult situations for their loved ones. We could also have a goal of keeping our affairs as private as possible. We want to make sure that upon our passing, things don't have to go through probate. Or at the very least, we may have just a small estate that can be handled in a pretty efficient manner. But the bulk of our estate is not passing through probate. We're trying to keep things as private as possible. And even during life, this is a great reason to set up a trust. You're concerned about a power of attorney not being accepted, or at least having some difficulties in dealing with a financial institution, or finger pointing and blaming as far as somebody acting as a power of attorney. And you just don't want to see a potential guardianship. And although the guardianship is not a public record, various interested parties would be a part of the guardianship proceeding, and you just don't want to see that happen. So you're going to set up this trust to make your affairs as private as possible and not have a wait and see approach, right? Wait and see if there's a problem. Wait and see if people start fighting. Wait and see if there's going to be a need. Kind of have a little bit of intuition working here with those red flags, and knowing I have a situation that I really want to make sure I've set up with trust in place, because it shows my intentions and it shows what I want. I set it up when I had no incapacities. I set it up when I was extremely well intentioned about what I wanted. You could also have business interests, and you have to be really proactive and think ahead as far as your business and what would happen during your life in the event you couldn't act on behalf of your business. You want to make sure you have the right person in charge. And if you set up a trust agreement and you can share with this person that they are the successor trustee in the event it's needed, you can start working on appropriate plans and what needs to take place in the event they're essentially called to duty, right? As the successor trustee of, let's say, a revocable trust. And this can be a saving grace as far as that business goes, and really needs to be a part of your overall business planning. It's not just about that business itself succeeding, but what you're doing to prevent problems into the future with regard to yourself and running the business. And then, as well, upon your passing, because the business is in trust, the business itself avoids probate, which again can be incredibly important. It's not a wait and see approach as far as what probate could look like. who may be causing problems, how difficult it will be to get somebody appointed, what else is going on during the course of the estate administration process, and so on. You could also have a goal of managing relationships. So people like to fight when they have grievances, and those grievances can come out at the time of a loved one passing. Those grievances can even come out during a person's life when an agent is acting under a power of attorney and another person is suspicious. What are you doing? I don't know what you're doing. I don't feel comfortable about this arrangement. This isn't what so and so wanted. And those types of, again, wait and see approaches can cause problems between relationships. And you want to be more proactive, intentional, and really engineer what you want, both during your life and upon your passing. We don't want to give people opportunities to air their grievances in a way that's going to ruin family relationships. We could also have a goal of benefiting individuals who should not receive outright distributions. We have minor children. We have incapacitated individuals, whether they are incapacitated now or into the future. They can't act on their own behalf. Or we could have supplemental needs persons who will be kicked off government benefits if they receive certain outright distributions. So we can manage assets through the trust and for those individuals. We can even have the trust named as a beneficiary on other assets. We could have life insurance where the beneficiary is the trust, or retirement assets, and so on, investment accounts, bank accounts. And this can be incredibly important as far as your overall picture goes and how you're helping people benefit in a way that is extremely helpful to them. You could also have just the concern of people spending money frivolously, spendthrifts, or people who have creditor issues, or people who are going through a divorce, and so on. So lots of opportunities to think about your goals, and then from there, the appropriate trust or trust to put in place. And from there, what assets are funding the trust or trust. And from there, we get into the weeds more and the appropriate provisions. I'd also like to just say that trusts are excellent as far as tax planning goes. You could have estate tax planning concerns, income tax planning you want to think about, or capital gains tax planning. And those are wonderful reasons why you could set up a trust. Even with estate tax planning, you could have a couple whose overall assets exceed the New York or federal estate tax exemptions, and we can set up a marital trust or perhaps two separate trusts and ensure we've got the right arrangements in place so that upon the first spouse to pass, we can soak up the credit allowed to him or her. And here in New York, we have a use it or lose it as far as that kind of credit goes. So we want to make sure it is used if we have estate tax concerns. We also have income tax planning where we do not want carryover basis. We want to step up in basis, so we don't want to outright gift to individuals. We want to make sure assets are considered to be part of an individual's gross estate and therefore receive that step up in basis. We also want to make sure that we can avoid problems as far as capital gains tax concerns. And so we can set up a trust with that in mind as well. So very important to think about all of these things, whether you have basic estate planning documents in place and you're just thinking about what else could be done, or you just know this is the time to really start honing in on goals and getting more intentional. Just one other thing I wanted to bring up, and that was real estate. Oftentimes people think it's so easy for various individuals to own real estate as tenants in common owners. And so you have people all owning one parcel of real estate in their individual ways, but all together. So tenants in common. And there can be just a whole host of problems with that. Who's making decisions? Who's contributing to pay for taxes and upkeep and homeowners insurance or whatever type of insurance is needed? You could also have people who are transferring their interest in the property to somebody else, or they pass and now their ownership interest in the real estate is going through probate, or they didn't pass with a will, and there's a whole host of problems now with the administration proceeding, and so on. So, real estate is a big one. People often have difficulties owning property together, and even that kind of ownership, if it's in an LLC, we have to think about people owning their LLC interests and what that looks like as well. So much to think about. I hope this did help. And if you're thinking about setting up a lifetime trust and you're in the Buffalo area, please reach out. I'd love to talk to you. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship. And I hope to see you on another video.